Thanks.
And if I can just remind me and Philip, that whenever, whichever one of us is not talking is supposed to monitor the chat
Okay.
and to see whose hands are up. Yeah.
Yeah, and I'll do that too.
Okay.
Yeah, thank you guys. Thanks everybody for joining us. Without further ado, I'm just going to turn it over to Phil Schrag. Thank you, Phil.
People are still signing in, which is fine. So I'm just going to say for a minute what we're going to do today in this webinar. So first, Lisa is going to discuss the problem method, the whole idea, the pedagogical theory behind the problem method, which is the basis of our book. And she's also going to talk about the architecture of the book, the different elements that go back and forth with each other as a student reads the book, how the book is used in class, and what is available to professors in the teacher's manual, more than 400-page extraordinary teacher's manual, and the companion website. And then Rob is going to talk about what's new in the seventh edition that isn't in the sixth edition that many of you have been using. Then it's going to come back to me, and I'm going to demonstrate how electronic polling can work in conjunction with teaching this course. And then we should have about 20 or 25 minutes for questions at the end and comments and conversations with all the rest of you. So, Lisa, it's yours.
Great. I'm so glad to see everybody. We have a lot of email conversation with people who are using our book, but we don't very often come face to face. And I know that some of you are longtime users of the book, and some are recent or brand new adopters. So we're going to try and talk to everybody a little bit. We're really excited about the seventh edition, which just went to the printer a couple of days ago, if you can imagine how thrilling that is for us. And we're happy to have a chance to talk about it. Um, so I started teaching PR in 1984, and I spent years puzzling over why this course seemed so much harder to teach than my other courses. I used several different books and experimented with lots of different teaching methods. And this textbook is kind of an end product of years of trial and error, not just by me, but by my co-authors also. And it reflects the view of all of us that students learn a lot more when they're asked to actively engage in sorting out ethical dilemmas during class than they do if they're asked to sit there like potted plants and digest doctrine being spooned down their throats. Um, so in most law school classes, the professor does most of the talking. The students are supposed to sit quietly, take notes. Sometimes the professor will engage in a dialogue with a few students, but most of the students are still principally listeners. And if you've ever tried to do that in a law school class, if you haven't done it lately, I recommend it because it's really hard. Um, so our book is designed to require that for most of every class meeting, the students would roll up their sleeves and work on some very challenging ethical problems, often discussing their analysis in small groups and then moving to a plenary discussion. And the book is centered on over 50 problems, nearly all of which are drawn from real situations, some from cases that have been litigated, some from news accounts, and some from the experiences of one or more of the authors or other lawyers who have shared stories with us. So to evaluate the problems competently, the students need to study the ethics codes and the other law that governs lawyers. Most of the didactic material is explained in the text, and it's intended to be read as part of the student's preparation for class. And our text is organized mostly into a Q&A format, and which kind of breaks up the text and keeps people awake, and it lets people know, why am I reading this? What's the point here? Uh-oh, you need to mute yourself, whoever you are, but welcome. um, um, so and in our writing of the book, you may or may not have noticed this, but Robin, Philip, and I are all like maniacs about conciseness and clarity. And one result of that is that each new edition, we pretty much rewrite the whole book, and update every footnote and really work hard to keep current, but also to be clear. Um, and so for each class, the students have to read a chunk of material and then prepare a few problems for discussion in class. They work through the analysis as part of their homework, at least they're supposed to. And they come to class then with opinions and questions and ideas about the problems. And their independent study enriches the discussion and allows them to learn as much or more from one another as they do from us. So during class, some professors sometimes explain some of the doctrinal issues, but the primary role of the professor is to act as a facilitator of the problem discussions. And if you analogize this to parenting, it's sort of like getting out of the way so your kids can learn, instead of claiming all the limelight for yourself. The instructor might introduce a problem with a quick summary and then divide the class into small groups of 3 or 4 students, which work together throughout the semester. And during the small group discussion, every student in the class is or should be an active participant. And the prospect of participating in small groups motivates the students to prepare for class, because lack of preparation is really obvious if you're working with a small group of people. And the small groups are like incubators for ideas and questions and discussion. So then the instructor might choose the most difficult question in a problem after summarizing the problem, and then ask the small groups to work on it for 5 or 10 minutes. And then the instructor will unceremoniously interrupt the small groups to lead a plenary discussion to see what the groups believe is the best, or at least the least bad, solution to the problem. One way to open the plenary discussion is to poll the students as to their opinions about what the lawyer in the problem should do. And Philip will say more about polling in a little while. Polling can be done using the technology that we're going to demonstrate, but it also can be done by asking for a show of hands on various options. People have different comfort levels with the technology, so I've done it both ways. So then once you get a sense of, how the class divides up on the various options, the students are invited to talk about the reasons why they chose the various options. And usually there are dramatic disagreements among the students as to what the lawyer in the problem should have done, and often very good reasons for the proffered solutions. And by doing this kind of rehearsing being a lawyer in an ethical hot
Hey,
seat.
just sent another link in the chat. The webinar has been moved to Zoom, so please use that link, and you should be able to access the webinar on there. Please let me know if you're still having difficulties, but the link in the chat should allow you to join.
I'm not sure who that was addressed to, but anyway, but the point is that this is like practicing dealing with hard ethical dilemmas, and it's meant to make students better at it so that when they encounter a real live ethical dilemma, it won't be their first time to the rodeo. So once the students have worked through a problem, the instructor can, by reference to the teacher's manual, which has all these goodies in it, explain what happened in the real case and what the real lawyer did and what consequences ensued. And often the stories, the real case stories, are shocking, and the students are aghast or horrified or something. But they also really appreciate learning that it was a real problem and that there was a real lawyer who had to make this decision. And often the lawyers made decisions that got them in a whole lot of trouble. And some of the students have just made those same decisions. So it's very thought-provoking. So anyway, that's just a thumbnail of kind of how the system works. And I have to say about kind of this structure that it's so much fun. And class is always a pleasure. And kind of gets the teacher out of the hot seat where the students are doing a lot of the work. And it also makes class very unpredictable. You never quite know what's going to happen. But anyway, we commend it. Yeah. Now we're going to Rob to talk about what's new in the seventh edition. Take it away, Rob.
Thanks, Lisa, and hello, everyone. Great to be here. Let me just say it's an honor to work with Phil and Lisa and our new co-authors, who I'll get to in a minute. It's just great. And what's so exciting about this work is everyone on this webinar, people who aren't who use the book, and ultimately students, because I've had I suspect some people will think, oh, this is PR, got to do it, required. Standard joke is I look at my large class and say, well, I'm glad everyone's interested in PR. Thank you for taking this class, which of course they have no choice but to take. Uh, but I think the pleasure of the book and using the book is people really do get excited. Students become engaged. It's hard not to be excited, and part of the book is structured with that in mind. In terms of what's new, let me say that let me start with this. What's new is on the front cover, which is we have two new co-authors, G.H. Hans from Cornell Law School and Ali Luciani, who's at Covington and Burling. They've added a fresh perspective also, and we really engage in lively discussions about how to make the book better. Some of what's new in the book might not even be that obvious. I'll get to some of the larger issues, but we go through the book with a fine-tooth comb, literally word by word, sentence by sentence, paragraph by paragraph, to make things better, to make it easier to read, to add clarity as a teaching tool. So this is as far of away from let's update this footnote or that footnote. This is a very substantial revision. As Lisa said, it's almost like rewriting the book. And we feel excited at the prospect that all of those changes, large and small, will really improve the book and make the teaching of it better. So more specifically, let me just pick out a few things that are new in terms of the full content. Now, there are some new rule news with the model rules. There's an exception. There's a addition to Rule 1.16, terminating representation, that has to do with addressing potential money laundering. There's a bunch of ABA opinions that have expanded interpretations, dealt with some interesting things. There are some broader new events. The Supreme Court, I'm sure you know these things, the Supreme Court has adopted a set of ethics rules. How meaningful that is certainly subject to debate. We have a Supreme Court opinion on affirmative action in law school admissions. We have the Alex Jones litigation, which involves clawback of information that was otherwise confidential. And then you might have heard of something called AI. I always forget what that means, but it's become such the talk of the town, and it raises many ethical issues, and not only hallucinations and false citations, which are the things that tend to get the most publicity, but actually a whole range of things relating to confidentiality and conflicts and even fees. Okay. Now, you might be aware that there is a new administration of President Trump, actually a new one and a new old one, and that has raised, again, you might be aware, a whole bunch of ethical issues that arise literally on a daily basis. The book needs to be current, And these are incredibly important issues. Now, some of them arose in the first administration, for example, the faked elector situation and the advice that Mike Pence got about the 2020 election. And then there are legal consequences for lawyers who are involved in overturning or trying to overturn the 2020 election. And then we have the cluster of issues that are arising now, sort of ripped from the headlines. For example, the big law attack, where the administration is trying to define what cases big law firms, Paul Weiss and the rest, are able to accept. Um, there's the case involving Eric Adams, the mayor of New York, although I'm not sure how long he's going to continue to be the mayor of New York. But the prosecution, and even more importantly, the withdrawal of the prosecution of him by the Trump administration. There's Alina Habba in New Jersey. There's Emil Bove and William Reveney, who talked about the colorful language of what the view is of judges, which I don't want to get blooped out by Joanne about using that salty language. So there are a range of issues that are incorporated into the book. Also, you'll notice that the incorporation is in lots of different places. Some of them are for example, some of them are incorporated into discussions. So it becomes fabric of the entire book, not just put out separately. And finally, the core of the book, as Lisa said, are problems. And we have added 5 new problems to the book. 2 have been omitted. They'll still be available. But we choose the problems very carefully. For example, one of the new problems has to do with taxes. It's a transactional case, which is important. It's about conservation easements, which I'm sure all of you have thought about recently. Another one is about fees, with some creative ways to attract clients and billing for those activities as a result of that. There's litigation involving government contracts and others. Now, as Lisa has said, we approach problems very carefully. They are designed to elicit discussions. They're based on real cases, and they work best when they don't have simple answers. And in addition to, I think, adding some interesting new circumstances for students to work through, I think they will succeed in doing that. And as we've mentioned, we have lavished a lot of attention on the teacher's manual, which goes into detail about how best to approach these just read a chat about how to approach these problems. So that's a taste of what's new. I think once you start using it, you'll see these things. And for new adopters, you'll be using a text that many people have found successful and that we like to think is even better. So I'll turn it over to Phil now.
Can I interject one quick thing?
Yeah, sure.
I'm just looking around at who's in the room, and I just wanted to mention that one of the reasons that the book keeps getting more interesting is that we get lots of ideas and material from our esteemed adopters. And so we have some reason to believe that Aspen will actually ask us to write an 8th edition. So those of you who are using the 7th edition, one thing you should know is that we want your stories. We want it when you come across something that's like something that you couldn't get out of your head for 20 years or something that keeps you awake at night. It's potential new material for the book, so don't be shy. And also feel free to let us know if you find mistakes or typos or things like that. So yeah, go back to Phil.
And to just prove Lisa's point, the case that I'm about to demonstrate with polling involves a situation that was brought to our attention by one of the adopters, Alexandra Lahav at the University of Connecticut. And she's acknowledged, as are several of you in the acknowledgements, and as Stephen Marcus is very prominently in the next edition, who's also on this call. So I'm going to talk about polling, and I'm going to do a little demonstration. But as Lisa said, it's important to understand the reason for polling. The reason is that in a normal class, somebody who's called on has to be on the spot and give an answer and explain their reasoning. But that's one person in a class of 50 or 100 people. And that's the only person who really has to think hard. With polling, every single student in the class has to come up with an answer to a difficult problem. And every student has to discuss their answer in a small group and then reveal their answer anonymously to the entire group. And then the electronic polling system, if you're using that, displays the results of the poll. And lo and behold, there's a 60-40 split most of the time, much of the time, or a 50-50 split among the students as to what the answer should be. Or if there are 5 possible options, there might be 5 different things that students want to do. And in the plenary discussion, then I call on somebody who voted number 1. Why did you vote that way? And we get some reasons out. Well, what about number 2? Those of you who voted for the second option, why did you vote for that? And why is that better than option number 1? And so forth. Also, the fact that people divide in the class has 2 additional, and can see that graphically, has 2 additional advantages. One is it shows that there are no easy answers to these ethical problems, that people reasonably disagree. And the other is that it demonstrates that nobody's alone. If you dare to speak out in a class of 100 people, you're terrified because maybe you're the only one who holds that view. But if you see graphically that 40% of the people agree with you, even if you're wrong, 40% of the people agree with you. And there are a lot of reasons justifying what you're doing. So I'm going to demonstrate this now by sharing my screen. And we're going to talk about a problem, one of the problems in the book. Okay, you should all be able to see my screen there now. Can you all see it?
Yes.
Okay, so we're going to now talk about this problem. First of all, you need to know 2 sentences of law that's relevant, that might be relevant to the problem, pertinent to confidentiality and the destruction or concealment of evidence. One principle is that a lawyer may not reveal information relating to the lawyer's representation of a client unless a very limited exception applies, and none of those exceptions apply to this case. And second, a lawyer may not destroy or conceal evidence if the lawyer knows that a government investigation is ongoing or can reasonably be anticipated. Now, here's the problem. For decades, you've been counsel to an historic Episcopal church that has a fine reputation in your community. In fact, the problem is based on a real case, and the church was the Christ Church in Greenwich, Connecticut, which George H.W. Bush worshipped at when he was a child. Your wife and daughter are active in church affairs. A couple of days ago, a church employee discovered hundreds of images of naked boys on a laptop computer that belonged to Howard Gardner, the choir director of the church. Possession of these images is a federal crime. The employee who discovered this informed the rector, who called you. You and the rector confronted the choir director, who quickly resigned, so the choir director's gone. No one knows about this except the choir director, now the rector, the church employee who discovered the pictures, and you. Even the vestry, the church's governing board, doesn't know about it. No charges have been filed. The rector wants to avoid any publicity about the incident. Any publicity could destroy the church's centuries-old reputation. The rector has just come to your office, told you about the problem, and handed you the computer. The picture in the lower right is the actual church that was involved in this case. So now we're going to do some polling as we think about the answers. So please, on your cell phone or in a new browser window, go to ttpoll.com, and enter the 6-digit ID number 705296, which you also should see in the upper right-hand corner of your screen. and simply skip the screen that asks for your name, because my polls are anonymous and for a reason. We don't want any student to feel embarrassed by their answer, even if they're the only one who votes for an option. And then you'll see a screen that lists answer numbers corresponding to multiple choice answers in the next slide. And you're going to vote by choosing one of those numbers at the bottom of the polling screen. And I'd like everybody who's on this call to vote. So is anybody having any trouble getting to tpoll.com? You all there? Entered 705-296.
Give everybody a minute.
ttpoll.com, 705-296. Yell it out if you need more time. Okay, I assume everybody's there.
They can unmute themselves.
You can unmute yourself and say, wait, if you need more time.
Mine says, please wait.
Okay, so here's the question.
Mine too, still waiting.
Yeah, I haven't opened the poll yet. Here are the choices. What will you do? Will you keep the computer in your office, but don't try to delete any files from it? 2, return the computer to Gardner, the choir director. 3, tell the rector to keep it in his office. 4, deliver the computer to the FBI. 5, try to delete the files, even though you don't know enough to be sure that there aren't backups in hidden files on the hard disk. 6, take possession of the computer and hire an expert to delete the files. 7, physically destroy the computer's hard drive or advise the rector to do so. 8, mention to Gardner that he could replace his laptop and send his current machine to a landfill. Or 9 other, be prepared to specify. Now at this point, before voting, before I open the polls, I would have the students get together in small groups of 3 or 4. These are permanent groups I create for the entire semester. So they all have gotten to know each other and they trust each other a bit, having worked together for weeks. And they talk about this. And people are allowed to change the opinion that they came into class with based on the discussion in the small group. But after 10 minutes, I'd give them 10 minutes to come up with their best answer to this. After 10 minutes of small group discussion, we open the polls like this, and now you can all vote. To 13, any last minute votes? 14, anybody else voting? 16, any more? 5, 4, 3, 2, 1. And here are the results. And you can see a huge spread of opinions. The plurality opinion is number 4, deliver the computer to the FBI, but there are plenty of other things. The one thing that nobody voted for, one of the things that nobody voted for is physically destroying the computer. Although some of you are going to return it to Gardner, and who knows what he's going to do with it, and so forth. So at this point, we would have a plenary discussion, and I would call on people who voted number 1, or I might start with number 4, since that was the plenary, the plurality view, and we'd discuss each of these options in the plenary class. And after we discuss all the options, and the discussion would include the rules that apply, the practical consequences, the costs, the exposure to the church, number 4 that the plurality voted for, delivering the computer to the FBI, violates the confidentiality of your client, the church, who doesn't want the publicity. Lisa.
Well, I just thought we could spend a couple minutes talking about what we actually think about this. And if we have time, do we have time?
Well, maybe we could during the Q&A if people want to, but I want to leave plenty of time for the Q&A.
Okay, but I just wanted to say that if you take possession of this computer, you're going to be, he will have committed a criminal act by possessing child pornography. So you can't do some of these options.
Another problem with keeping the computer in your office is that the government rarely gets search warrants for searches of the lawyer's office. So you might be helping to conceal this from the government.
Right, but right now we're demonstrating the difference between the teacher telling the students what to think and the
Right.
student.
Well, the student, I'd pull out all these pluses and minuses, all the advantages and disadvantages from the students rather than commenting myself, although I would have some comments perhaps at the end of all that. And then after we've had a full debate of this, I tell them what happened in the real case, which involved a guy named Philip Russell, who's a prominent criminal defense lawyer and a
Maybe
former
take the
prosecutor.
slide down.
Pardon me?
Do you need the slide?
No, we don't need the slide.
Go back to the group.
Stop the share. So Philip Russell was a prominent criminal defense lawyer. He was a former president of the bar of Greenwich, Connecticut. The choir director, Robert Tate, had worked for decades at the Christ Church in Greenwich. And Russell, the church's lawyer, was present when Tate resigned. Russell had no reason to know that an investigation of Tate was pending. That's important because, remember, the rule said if you know of an investigation, you can't destroy evidence. But he had no reason to know that there was an investigation, although, in fact, the FBI had independently started an investigation of Tate for possession of child pornography the day before the church employee discovered the pornography on the computer. The church wanted to avoid any adverse publicity. They were desperate to avoid publicity. Russell knew that possession of child pornography was unlawful, so he couldn't give the computer to his client, the church. Within an hour of Tate's resignation, therefore, he took the laptop computer to his office and pulverized the hard drive. When contacted by the FBI, which was trying to locate Tate's computer, Russell immediately stated that he had destroyed it, and he was indicted under the obstruction of justice section of the Sarbanes-Oxley law.
I think he used a hammer, right?
He used a hammer, and he was arrested by federal authorities. Now, the indictment didn't charge that he knew that a federal investigation of Tate was underway, because the government apparently took the position that actual knowledge of an investigation was not a necessary element of the crime of obstruction. He challenged the indictment on the ground that it couldn't be applied to a lawyer who was unaware of a pending investigation, but he was so worried about the possibility of being convicted that he pled guilty to misprision of a felony, meaning not telling somebody about a felony. And he was sentenced to 6 months home confinement, a fine of $25,000, 240 hours of community service, and a 6-month suspension of his law license. So that would be the end of the discussion of the real case. I would usually, if possible, have that discussion end at the very last second of the class, because I like to leave my classes with a bang, and that's a bang when the guy loses his license for 6 months. I try to do that with respect to every class. I just want to say one more thing before we open up for questions and answers, and that is that the particular brand of electronic polling that I just demonstrated for you is, in my opinion, the high end. It costs for me to teach, I have 88 students this semester, and it cost me about $1,000 out of my faculty research account to buy the licenses for the 88 students to be able to use this for a semester, and for you to be able to use it. There are cheaper versions. Some of your schools have free versions because your university has licenses for them. I don't think they're as good. For one thing, some of the other brands require you to put your questions in and the polling, all the polling stuff in a single slide, and don't allow enough text to be in the slide. You couldn't display a full page of text in the slides they allow. And others don't allow you to ask impromptu questions. I sometimes, and something comes up in class, and I say, well, let's poll the class on that. And I write out a couple, I say, what are the options here? And the students volunteer several options, and I'm writing them down on a Word document being projected to the class, and then we vote on that. So there's no slide. The students create the slide. This polling technology that I use, which is described in depth in the teacher's manual to the 6th and 7th edition, this technology is expensive, but I think the most versatile, and it also is very colorful. So with that, let's see if we can have some discussion, questions, answers. By the way, one of the reasons I did this demonstration is that Aspen did a survey of our adopters before we started to work on this edition. And to my surprise, 40% of our adopters are already using electronic polling technology. So I hope we move that up to 50 or 60 because I think it's the best way to teach this course.
Another footnote on this that maybe we didn't mention, maybe those of you who know the book know this already, but we maintain a website that has an electronic copy of the teacher's manual and slide decks for each class and audio recordings of interviews with some of the lawyers. And what am I missing? Oh, and some other materials that have been taken out of the book that some people still like to use. So if you're using the book and you haven't investigated the website to see what's there, there are a lot of tools there that might save you many hours of prep time and help you make class fun.
Two things about the slides that are available on the website. One is that a lot of them contain copyrighted images that you're allowed to show in class under the fair use doctrine. You can't distribute to the class, so we couldn't put them in the book, but you can show them from the slides. And other slides have problems and potential answers like these, like the ones that I showed you. So there's lots of material in the slides in the teacher's manual, in the website. Okay, let's open it up. Will?
Uh, One question is our university has already licensed for polling data. It's called Poll Everywhere. It has its kinks to it, but I've been using that. And I find it very successful too for all the reasons that you say. What adaptation I do is I have the groups broken up like you do, and then whoever voted for one versus four, I would have a spokesperson from their little firm explain why, and then the other group would explain why. And so you have two student views being there. And then I'd ask the class, well, having heard from each of them, who do you think then has the better case?
That's great. I haven't done that in part because I worry that my students are so shy about expressing their opinions before they know how many other people agree with them, that they're just reluctant to speak until I show
Oh,
the
well, I think our
slides.
part is to encourage them to be advocates. So say,
Right.
if you're going to be lawyers, you better learn how to talk.
Yep.
Yeah. I know what you're saying, but
Yeah.
it's encouraging them and say, hey, there's 40% of you out there that say that. And so if we're not ready to advocate, then we're not going to be good lawyers.
Agreed.
That's a good idea. One of the things I think is really fun is to take the least popular view in the poll and say, okay, somebody who took that position, tell us why. Because then the rest of the class is usually pretty quickly turned on its head.
Mhm.
So, but I don't, I think one thing about this is I think if you went around systematically trying to get the views of all the groups, you would eat up all your class time. And so all you can really do is get a sample.
I think Erwin had a question.
No, I just put a thumbs up to encouraging students to speak up, and I'll tell you, I know it's slightly off topic, but it amazes me that you're going to be lawyers, and I tell them, listen, you're going to be somebody else's voice. You better use yours, and starting now. I mean, when it has no consequence whatsoever. But I love the book, but I know I didn't have anything substantive to say.
That's okay. Where are you? What school are you at?
I'm at a place that usually has high standards in the teachers that they hire. Rob Rubinson, for example, is teaching at University of Baltimore. They may had the misfortune of scrounging the bottom, and there I am. So, but I teach there. I teach at American, and I also teach and use your book at Temple as well.
Oh, wow. You get around.
I
Great.
do.
Other thoughts, comments,
We
questions?
we'd be happy to chat about anything at all related to the book.
Yeah, I have a question. My name's Kellen Haid. I'm an adjunct at Seattle University. Love the book, love the problem based. Uh, I'm curious, I've been struggling with how to incorporate, AI, which changes like every day. I'm curious how you guys incorporated that into the new edition. Is it kind of by chapter or are there standalone kind of AI component, like a standalone AI chapter, and cloud computing and all that? Um,
There's a section in at the end of chapter 13 about the advent of AI and what it means for lawyers. I'm pretty sure that by the eighth edition, that chapter will get a lot bigger.
But I think it comes up elsewhere in the book. But we've addressed it substantively only in one place.
I would echo that I just was talking with a colleague of mine. We each have two separate sections, and we brought in our uh, technological law professor who does AI and in charge of that. And we try to hone it down to client confidentiality, communications, what rules most apply to the use of AI, with the theory that law firms are going to use AI and people are going to go out in the law firms and they better know what the bounds are. But we're like you still trying to explore what they are, and we're trying to find the rules that most apply and use an AI discussion in connection with those particular rules.
Good. There was a question in the chat about concise edition. There was a concise edition until the sixth edition. When we wrote the sixth edition, we cut we cut out providing a shorter, concise edition because we cut down the sixth from the fifth to the sixth edition, made it shorter, and now the current editions are concise editions as well as full editions. But Lisa, who is our master at developing sample syllabi, has put into the teacher's manual a sample syllabi for 2-credit courses. So for those of you who are teaching 2-credit versions of this course and might have wanted to use a concise edition, you can use her sample syllabi for 2-credit courses to teach the course in a more concise form for with that syllabus for a 2-credit course.
There's another question in the chat, but I wanted to go back to AI just for a second because one of the many scary things about AI is that for a problem book, a student could just feed a problem into AI and get an instant analysis and not have to think at all. And same with take-home exams. It's just like we're not sure how the only thing we know about this that's really important is for nobody to share the teacher's manual with anybody except the teachers teaching from it.
I have actually fed some of our problems into ChatGPT, and it hasn't done very well with our problems. They're too fact specific, too complex for AI, at least at this stage, to be able to solve.
Joanne, do you want to answer the question about that you did in the chat?
Sure. Yeah, I just popped in the link to the product page for the 7th edition, which is on the aspen.com site, where there's information that we've talked about today in terms of things that are new. The TOC for the new edition is available there. We're going to probably be posting some additional resources related to the 7th edition, but yeah, that'll be out November 1st. So,
I'm going to post a sample
you can
syllabi,
reach
right?
out to your,
I'm sorry.
yeah, I think we're going to post, the sample, so that's okay. Sample syllabi and some, like I said, some additional resources. I know that for those of you that may be teaching the course this spring, obviously you're going to want access to this information as soon as possible so you can think about whether you might want to use the new edition. So, you can reach out to me or your local sales rep to make sure that you've got access to all the most current information on the new edition and that you're on the list to get a copy as soon as it's published.
Also, as with past editions, the teacher's manual, the printed teacher's manual, will be packaged with your examination copy of the new version of the textbook. I'm very proud that our teachers, Aspen loves our teacher's manual, and so it's the only one that they print, that they put in print. Everything else is electronic.
I
It's
could.
Right.
partly because we're old fashioned. Go ahead, Rob.
I should also add that the eighth edition will be written by AI, and you should all be aware of that. But that'll be. But
Rob, this is being recorded, buddy.
but another advantage, particularly for those of your adopters, is the structure of the book remains, the bones of it, if you will. All of the new things that we've been speaking about have enriched the book. And it gives you a good opportunity to build upon the syllabus that you have. You certainly should rethink it in light of the book, or as we said, Lisa's developed some great ones. But the structure of the book is still there, and it's something that you can still draw upon as you develop your new syllabi.
Also, in the introduction to the teacher's manual, we list chapter by chapter all the changes that we've made to make it easy for you to modify your notes and know what's different.
Is that
Even where we've
available?
changed the name of a party.
Wait, Will wanted to get in. Yeah, go ahead, Will.
Is that available for next semester? When is it out?
November 1st.
The teacher's manual?
Everything-
Yeah, I was going to say the book's November 1st. That you guys they've already completed the teacher's manual. And so if you are planning to adopt the seventh edition, we can get you access to that seventh edition teacher's manual as soon as possible because we have availability. Happy
one thing
birthday,
about
Jim.
this-
Thank you.
One thing
You
about
get a free
this
copy of this
is
book.
you know, we all have used multiple editions of other people's books, and we know from an adopter's perspective that having a new edition come out can be kind of a headache because you have to go through all your class notes and see what's changed and what's the same and all that. And you should know that when we're discussing making changes, always in the back of our minds is this going to be more of a burden for the adopters, and is it worth it? So we have made changes, but we try not to make stupid little changes that will just cause people's notes to be wrong.
As an example, however, we had to change the drugs in the drug test, because it used to involve drugs that are now so widely acceptable to the younger generation that those drugs didn't seem serious anymore. So now more challenging drugs are in the drug test problem.
What did we change it to?
PCPs.
Yeah, I think we changed
MDMA.
First it was pot, then it was weed, then it was
that was in
alcohol.
the first. That's in problem 1.1. This
Right.
was the drug test had.
Oh, in the drug test, right?
It had
Right.
amphetamines and marijuana. They're
Oh,
gone.
right. Yeah. And sometimes we have to consult with our younger friends about what's going on out there.
Advantage of having newer co-authors who might be more familiar with it.
And
Current
children.
culture. Yes.
Well, they're very quiet. Is there anything else we want to
Yeah.
tell?
Yeah, I was just going to say, it seems like people have had most of the questions they had responded to. Certainly, as you guys know, likely as adopters, we have an amazingly responsive author team, and I think they're open to your reaching out if you have questions. Certainly, reach out to myself or your local Aspen sales rep. If
Or
you
Lisa.
have questions about availability, or Lisa, right? Or Lisa, or Phil, or Rob. Yeah. But it was really nice to just have some time with everybody here, get to know you guys a little bit better. And I'm especially grateful, obviously, to our authors for their time today. We'll be following up. I'll send a copy of the recording to everybody who's attended today in case people were late. I know there was a little bit of some tech issues with the webinar and the Zoom call, and apologies for anybody that got stuck in that loop of trying to kind of shift from the webinar on Teams to the Zoom call. But thank you for your patience with that. But yeah, I'm hoping everybody's got some fun weekend plans, and looking forward to the publication of the book in time for Jim's birthday. So when you get your copy, you can thank Jim.
We're looking
And we-
forward to getting the
yeah.
copy.
I want to express
Great.
appreciation to Joanne and to the rest of the Aspen team because this is a project with many moving parts, and there have been so many people involved who have helped us so much. But so thank you.
Thank you.
Joanne has been
Yeah.
especially helpful in recent months. I mean, you're always
Thank
helpful,
you,
but
Lisa.
you know what I mean.
Thank you. Yeah, I appreciate that. Yeah, so unless anybody has anything else, I think we are good. And unless the authors have any final words of
Final
advice,
comment is
parting.
if any of you are thinking of writing a textbook in another subject, of course, I think Aspen, it's the best. They have a terrific editorial team, and they work with you from beginning to end. Many editors work with you. They make a first-class product.
Thank you, Phil. Well,
Well,
on that wonderful note, what more can we say?
I think we're
Lisa.
done. It's nice to meet everybody, some of the people.
Thanks
Some
very
people
much.
are
Yeah.
incognito, but that's okay too.
Yeah,
Yeah.
thanks to everyone for coming.
Yeah.
Okay.
Good
Okay.
to see you. Happy weekend. Bye, everyone.
Thank you.